All of it is gone.
Yeah.
And with it, also went the local content designations. So that as we sit here today, now, Sean, there are no legal obligations
to comply with,
to do any of that. And I think it's a difficult spot.
Yeah.
Because it's not just that there's no obligation. The more difficult question is whether there's authorization, right? So if you are going to adjudicate a tender tomorrow, and you are going to disqualify a bidder because they didn't offer you a minimum local content in a designated sector, you are going to be at risk. Because it's a very, very difficult analysis to figure out whether you've got the legal standing to actually do that. I don't want to for one moment suggest that I can just sit here and categorically say you don't. It's not that easy.
It's not easy. So
but there's a risk.
Are you saying if somebody issued a tender, 2 months ago, they haven't yet awarded it, they're sitting in an evaluation committee or an adjudication committee, and they're now deciding whether the entity, the supplier, the bidder complied with what they put in that tender document, that's a big question. Can they even say now, can they use,
who knows,
the ranking? Yeah.
Who knows? On one, and there are different views here, and I'm certainly not suggesting that there's an easy answer. On one reading, one can say, well, if you had it in your tender documents and your own SCM policy, including your preferential policy, which, as we know, in most cases, just the same document, allowed for it, then it might just be okay. And you can just continue to do that. On another reading, or another line of argument would be to say, well, the very basis upon which you formulated all of that, so not only the individual tender and its requirements, but also your own policy, has now disappeared. So that you actually didn't have the legal mandate to do it, or at the very least, your legal mandate was very, very seriously skewed by an instruction, what in law we would call either fettering or a dictate from an unauthorized source. And what yesterday's judgment made very clear is that the minister was unauthorized to create the regulations, which there's no doubt. If you go through our country up and down, you look at SCM policies, you look at the preferential part, there's no doubt that they've all been dictated by the regs, right?
Absolutely.
I mean, I don't think we can get away from that reality.
Every organ of state.
So you will be at risk that that a supplier will take that line and attack your SCM policy, your preferential part first, and say this thing was premised on what we now know was an unauthorized instruction, regulation. In law, we would call that a dictate. And because of that, you took certain steps. And because that basis has now fallen away, everything that followed is tainted.
Prof, is there a difference in risk if the tender document used regulation 4 and 9 versus the other regulations? Is there a different level?
No.
Because I thought the Supreme Court of Appeals said that 4 and 9 was unlawful specifically, and then declared the entire regulations invalid because of the interconnectivity of the whole thing.
Yeah.
Is there a different scale of risk?
Not anymore. It was after the SCA judgment, but that's where it's very important now to remember that the reasoning of the Constitutional Court replaces that of the SCA. And the reasoning of the Constitutional Court is much more blunt, right? They've simply just said the minister doesn't have the power to create any of this. Whether we're talking about 9 or 4, or even more critically, 6 or 7. The
80,
minister
20,
never
90,
had
10.
the power.
Yeah. Yeah.
Nothing. I mean, the 80, 20, 90, 10 is in its bare bones in the act, but particularly how that 10 or 20 is to be decided, which has been the big move, right? Since 2001, 11, 17 now.
Yeah.
That's been the space where that has now gone all out of the window. And I think, to be honest, I think that is exactly what the Constitutional Court had in mind, that it's not up to the minister to be so prescriptive. And in that sense, and I think this, Sean, based on our discussions, this is where I think you take a bit more an upbeat view of this than I do. This is where the power has now been largely handed back to organs of state, as we had it in the pre-2011 regime, where entities basically within those very broad parameters of the act itself can just decide how they're going to interpret the 10 or the 20, what is going to go into the calculation of the 10 and the 20, and then run with that. It's now clearly, the court has now confirmed that is the power of the organ of state, not the minister.
So if I'm a public entity sitting here now, I guess there's a whole risk decision process that needs to take place on the tenders that are not yet closed.
Yeah.
Should there be any concern about tenders that were closed and awarded before 10 a.m. yesterday?
No, those will be safe.
Okay.
Because the law, that it wouldn't work retrospectively.
It's not going to retrospectively apply.
No.
Okay, so it's anything not yet closed, and hence anything that they plan to issue.
Yeah.
Quotations, anything really, which has got some reference to an element of the regulation needs to be re-looked at. Yeah, absolutely. And the way to do it would be to, as quickly as your entity allows you to do, is to basically adopt a new or revised preference policy. So I mean, the best practical advice I can give is to say, with the best speed that you can muster within your organization. And I know that that is saying a lot, because some of these entities must go to their boards and things like that. It's not an easy thing, but as quickly as you possibly can, get your preferential policy kind of basically cleaned up. I mean, you can do it. And this is, if you go back to the judgment now, Sean, I think this is what's quite interesting. You also showed one of those extracts, which I think is very interesting, for me, very frustrating, because the majority judgment is just not clear. So yes,
they flip-flop around, what exactly is the meaning of 2171 versus 2, which is the big, elephant in the room. That's the big question we want answered. The SCA went one direction. I disagree with their direction, but at least they dealt with it. The CC now is really just flip-flopping over that question. So early in the majority judgment, they make very general remarks about, we agree with the minority about the objectives, but they don't go into the detail. And then later on, they make this odd statement in paragraph 116, and I think you also had it on the screen at some point, where the majority says, happily, both the first judgment and this judgment, and indeed the minister, understand the impugned regulations, so those are the 2017 regulations, to do what is envisaged in section 2172 of the Constitution. Now, what does that mean? Does that mean, if you're now an organ of state and you're thinking about, okay, so what are my options? I've now got the power. What can I do with that power? And I think that's the question that Ron's also just asked.
Right.
Does paragraph 116 now mean that you can simply take the 2017 regs as they are, and you say, oh, I quite like this. I want to continue doing this as is. I don't care about the fact that the minister came up with this, and we know now that he wasn't meant to impose it on me, but I like this. So I now adopt this. Is that almost kind of offhand statement in in paragraph 116 a mandate for you to then say, well, the Constitutional Court has said that these impugned regulations do what is envisaged in section 2172 of the Constitution. With other words, by implication, they are constitutionally sound, which is a big question. I mean, a lot of time was spent in both those courts arguing exactly that point. To what extent does this whole notion of pre-qualification, reservation, mandatory subcontracting, to what extent is it aligned with the constitutional wording in 2172, which on one reading suggests preference, but on another reading is a little bit more open-ended? We don't know. And yeah.
But if we're suggesting that organs of state quickly update the SCM policies and their preferential procurement policies, at least this is a starting point, right? There might be some debate down the road if there is a challenge, and
yes,
but at least it gives them a starting point.
Absolutely, absolutely, and that's also why, I mean, I said to somebody yesterday in one of these conversations that I wonder, and I've not checked who's on the call, might be relevant people on the call, but I wonder whether what are they called? Afri-Business. I wonder whether they realize that they've actually not won. I wonder if they understand that.
One of those
they've actually lost.
Implications, yeah.
Yeah, absolutely.
Yeah.
So their intention was to do away with pre-qualification. That was really their big intention. Well, I don't think they've succeeded in that. All they've done is they've made it much more difficult to fight it. Because now, whereas up to this point, they had to fight it nationally at one point. Going forward, they'll have to fight it at, I mean, Sean, you keep
at a tender level,
on this,
right?
Yeah, at a tender level, at an entity level. How many entities do we now have? That's
720 plus.
Yeah. So they've got 720 plus potential challenges ahead of them, and many of those could be much more strict than anything we had in the regs. And I can tell you now, a conversation we've been having over and over again since 2011 has been, what does localization mean? Does it mean South African? Or does it mean Cape Town? Or Gauteng? Or what does it mean?
Yeah,
absolutely. And we all know, that outside of national government department thinking, every entity in this country wants that word localization to be much more narrow, for their own purposes.